Number 43, it is the people of the state of New York versus Jaime Lopez-Mendoza. Thank you. Good afternoon, counsel.
Good afternoon. With this court's permission, I'd like to reserve 2 minutes for rebuttal.
You may have 2 minutes.
Thank you. Christina Swarns for the Office of the Appellate Defender on behalf of Jaime Lopez-Mendoza. This case raises the question of whether constitutionally effective counsel can pursue a theory of defense that he knew or should have known would be proven false by the prosecution's undisputed physical evidence.
Well, this case to me is a little different than the previous case in terms of what we have on the record. We have this sort of, what seems to me, an ambiguous discussion about what trial counsel had done in terms of investigation, what he knew, what he didn't know, what conversations he may have had with his client about it. How can we decide this one on this record?
Sure. So because there are literally only 2 explanations for counsel's decision to pursue a defense that he should have known would be proven false by the prosecution's undisputed video evidence. So we know from the inception of this case, counsel knew that the prosecution in this case had video evidence. As it turned out, and the defense counsel pursued a theory of defense, which was that Mr. Lopez...
Sorry, when you say from the inception of the case, can you give me a date?
I don't have a date in front of me, but it was certainly in the VDF that the prosecution had video evidence.
But it's 2 days after the incident that the defendant testifies in front of the grand jury.
That's
correct?
right.
Do we know whether counsel had the video at that point?
I don't think he had the video. He had notice of the video.
Before that? Before that?
Right.
You know that? You do know that or you don't know that?
Do I know whether he had seen the video before that?
Do you know whether he had the video by the 29th of December?
I don't know the answer to that. But what I do know is that from early on, let's say then, in the beginning of the case, before this case went to trial, counsel knew that the prosecution had video evidence, and counsel made a decision at the outset to go to this trial and present a theory of defense, which was that Mr. Lopez-Mendoza engaged in consensual sex with a complainant at 238.
Counsel, how do we analyze defense counsel's attempt to strategically recognize this man's testimony before the grand jury and what he did at trial?
So the video, of course, disproved the 2:38 a.m. defense. So counsel's obligation, right, before they went to trial, was to A, have reviewed all of the evidence that he knew to be in the prosecution's possession, that he knew or should have known that the prosecution was likely to use in its prosecution against Mr. Lopez-Mendoza, and then pursue a theory of defense that reconciled with all of the evidence that was known to him or should have been known to him.
But how does he reconcile the grand jury testimony with the video?
Well, counsel had a bunch of options, right? In this case, counsel opened and said that his client was going to testify to this 2:38 a.m. Consensual sex defense. That wasn't an obligation on counsel.
Well, I wasn't asking all the different ways that he could not reconcile them. I want to know how he could reconcile them.
Well, that assumes that counsel was locked into pursuing a theory of defense, which was consensual sex at 2:38.
Well, which was consistent with the grand jury testimony.
Correct, but this was also a case that was riddled with reasonable doubt. We have a complainant who was unquestionably intoxicated. We have a complainant who, on the evening of the offense, was committed to the idea, inexplicably committed to the idea, that the assailant was in room 206 even after she accused...
He did bring all that out at trial.
He did, and so this is a case that was riddled with reasonable doubt. So counsel made a choice to pursue a theory of defense that he knew or should have known would have absolutely failed in front of this jury in the face of other alternative defenses like reasonable doubt that wouldn't have failed that way. We also know that at the outset of the trial proceedings, the court in this case offered Mr. Lopez-Mendoza a plea, right? There was a plea on the table from the court of 5 years plus 5 years PRS. counsel could have urged his client to seriously urge his client to take that plea.
And do we know that he
But you don't
didn't?
know that he didn't do that.
What we do know-
And that brings me to the same question I asked in the last case is, don't we need a 440 here to flesh out this record?
Well, what we know is that what counsel actually did in this case, the decision that counsel actually made was to pursue a defense that he knew or should have known would absolutely be disproven by the prosecution's evidence. The only way he could have made the decision to pursue that defense was either A, by failing to watch the video and recognize that that video ran in complete conflict with the defense that he had chosen, or B, that he did watch the video and then presented it anyway. Whether you choose route A or you choose route B, counsel's decision here was objectively unreasonable.
What if any weight is counsel permitted to give what his client tells him about? So here he's got these hundreds of hours of video, and he doesn't know until he's right there at trial that supposedly these particular time frames will show his client in another part of the building. So is he not permitted to take into account what his client tells him in terms of the value of his going through those hundreds of hours of video? Is it ineffective for him to take that into consideration?
No, he's required to take that into consideration. Counsel, of course, has to consult with his
Okay, so how
client.
do we know that that conversation between him and his client didn't take place?
We don't know that.
Okay,
But
so
even,
so isn't that what a 440 hearing is for?
no, because even if, let's just assume that Mr. Lopez-Mendoza was emphatic about the idea that what happened was that he engaged in consensual sex at 2:38 a.m. Counsel's duty was then to effectuate that defense, to push forward that his client's chosen defense in recognition of all of the evidence that was known to him, in recognition of all of the evidence that was going to be presented against his client. You can't blindly accept what your client says and pursue a defense and close your eyes to the evidence that you know the prosecution is going to present. If he knew that this was the defense that his client was wedded to, and he knew that the prosecution was going to introduce this video, then it was incumbent upon counsel to aggressively seek to, for example, exclude the video, right? Make a challenge on reliability grounds, admissibility grounds, challenge chain of custody, make a meaningful effort to effectuate the defense that his client has urged him to pursue. None of that happened here, and none of that happened here in a case that was,
He's also
again,
not required to, the lawyer picks the strategy, regardless of what the client says, right? Ultimately, we don't know what really happened here, and he doesn't. I mean, he can choose to take I'm not saying this is a silly defense, but let's say the client wants some silly defense. He or she may choose to pursue that after discussing it with the client or not.
that's right. And if, whether, so it sort of brings me back to point one, which is whether Mr. Mendoza urged this defense on him or whether a client chose this defense. There are only one of two ways, and my red light is on, that they could have gotten to the place where this defense was presented to this jury. A, they didn't know that the evidence that the prosecution was going to present in that video would completely undermine that defense, or B, they did know that that was going to happen and they presented it anyway, which is inexcusable and objectively
He
unreasonable.
didn't have a lot of choices here, really. I mean, one, he had the grand jury testimony he had to deal with. And two, which we haven't mentioned yet, there was DNA evidence. So he was really limited in, it's a consensual encounter, and then I have to fit it in a time, and there's all this videotape. So isn't it really, as I think has been suggested, why did you do that? I mean, what other options did he have? What was the client telling him? All of these are hearing issues.
Well, again, I think in terms of the question of the impact of the DNA, I just want to take a moment, I know my red light is on,
May.
to flesh this out. So what we know is this case was riddled with reasonable doubt. This jury acquitted Mr. Lopez-Mendoza on the criminal sexual act charge, right? And that obviously is a repudiation of the complainant's testimony because the complainant at trial testified that she was the victim of oral vaginal contact.
But he was convicted of first-degree rape.
Yes, and in combination, I just want to finish my thought, in combination with the absence, right, of saliva or DNA. So that's how they get to the acquittal on the criminal sexual act. So then you have rape. And what the jury was confronted with respect to rape was a complainant whose credibility they have found to be compromised, and Mr. Lopez-Mendoza, whose defense is perhaps self-serving, right, of consensual sex. But then what happens here is that defense is completely destroyed by the video. As soon as the prosecution presents the video, the defense, right, to counterbalance the questionable complainant's theory, because they've already acquitted on one count, right, is destroyed. So you have defense counsel saying, disregard my defense. You have the prosecutor in her closing argument walking this jury step by step through the video that completely undermines the theory of defense. You have the prosecutor in her closing argument spending her time pointing out how the defense was destroyed by this video, and we know without question that those things had a profound effect on this jury, because the first note the jury sends out asks for a bunch of things, including the prosecutor's summation and the video. So there's no question in the context of this weak case.
Does the grand jury testimony get in if he doesn't testify?
No, I don't believe it does. Right?
So he could have avoided in the opening making any reference to the time frame?
Absolutely, he could have presented a reasonable doubt defense, right? If constitutionally effective counsel should be making these decisions before the start of trial, right, taking into account the reality of this videotape in the context of this claim of consensual sex immediately after they go in the room. That is the time at which those decisions should have been made. Counsel clearly did not do that. We know that from this record because, again, only one of two things happened. He watched that video and inexcusably presented a defense that he knew or should have known would have blown up in his face in court, or he didn't watch the video and he presented a strategy that was completely born in the blind.
Thank you, counsel. Counsel?
Good afternoon, Your Honors. May it please the Court. My name is Susan Axelrod. I represent the respondent. I just want to set the record straight on a couple of things. At the time that the defendant testified in the grand jury, there had been no indictment and there had been no VDF. The defense did not know about the videotape. I'm not sure that the people knew about the existence of the videotape. Obviously, it's a hotel, and it's likely to be something that exists. But when the defendant went into the grand jury, the defense had not seen the videotape. The defendant, however, is an employee of the hotel, and one would have expected that he might have been aware that there were actually cameras all over where the employees worked.
You know, though, the opposing counsel closed by positing a conundrum, assuming the videotape was not watched in its entirety. You have a choice between an incompetent investigation or, assuming it was watched, then you have a choice with incompetent representation. But it's inexplicable not to watch the video, I guess, is the core argument. Otherwise, your argument is on the horns of that dilemma.
Well, first of all, on this record, it's unclear as to whether or not he watched the videotape, and we're all drawing inferences from that. One thing that I'd like to point out is that at the...
Well, how can that be, given the colloquy? I mean, given the colloquy.
The colloquy, he never said he didn't watch the videotape.
But the prosecutor insists over and over.
Well,
I told him about it, he's had it, I told him a month ago,
That
the
doesn't
judge asked, did you watch it?
And he didn't
finesses
answer.
it, right, and if he had watched it, one would think, he would say, of course I watched it.
Well, maybe, but again, it goes...
Excuse me for a second. At 2:19, the court asks, have you seen the video? And the answer is yes. So I'm confused about whether he saw it and when he saw it and what happened.
It was definitely given to him.
He was asked seen, which is ambiguous perhaps?
I think the record is a little bit ambiguous, which is one of the reasons we were arguing that you need to have a 440 to understand that.
I thought he said he had received it.
Yes, but he...
I thought the question was, do you have it? Have you gotten it? You're not arguing that you didn't get it.
I'm not arguing that, Judge.
No, not you. Isn't that what the judge is, the colloquy?
Yes, but the other part of the colloquy
If he said, I saw it, we wouldn't be in this kind of an argument.
That absolutely not.
He doesn't expressly say, I saw the video.
But weren't they primarily focusing on the redacted video that the people wanted to offer into evidence?
Exactly. This is a truncated conversation, not about what defense counsel did or didn't do, or how he spoke to or didn't speak to his client. It's whether or not he was entitled to see this particular exhibit before it went into evidence.
Yes, but the whole point is that the prosecutor is saying, I told him a month ago that the video does not bear out the grand jury testimony. It's not hours of video. There's only a certain period of time that's at play.
Except when you see that videotape, from what the Mr. Fong, who was the one who put that tape together, said, there's 26 cameras all running at the same time, and they all pop up at the screen at the same time, which means you have, even in an hour's worth of time, you have 26 hours right there all popping up at you. Now, it is possible, because he was speaking with a hotel employee who had worked there, who did not have a criminal record, that he actually made the decision that he was going to believe or put faith in what his client was telling him, which was that the video wasn't all that significant. Why he didn't seem to understand what the prosecutor said, we don't know, because there was no other...
Is this argument now that if your client tells you, no, this is definitely the way this went down, that excuses that you may not look at the relevant parts of the video, or you don't look at the video?
Again, Judge, we don't know that he didn't look at the video.
26 hours sounds like a lot less than hundreds.
We don't know that he didn't look at the videotape. What I'm saying is, in this circumstance, with this particular defendant who actually propelled his testimony...
I'm saying, let's even assume, the counsel makes, I think, an interesting point. Assume he did look at it.
Did or did not?
Assume he did look at the video.
Did.
Yes.
Okay.
Then what explains the course that he took?
He only had one defense in this case.
Then why does he switch after this? I'm not understanding that.
I don't understand. He doesn't switch defenses. He opens on a consensual sexual act when the defendant goes into when the defendant helps the victim and her boyfriend into the hotel. He sums up on a consensual sexual act when the...
well, that aligns with the grand jury testimony. I'm not asking about that.
But that's his defense throughout the trial. He never deviates from his defense.
Why does he say the client's going to testify and then
that
not?
That was a misstep, and it was a misstep that attorneys sometimes make. But this court has not, with very rare exception, has this court set aside a conviction, especially without a 440-10, on one misstep without looking at the rest of the record. When you look at this entire record, this defense attorney was very effective. His objections to the DNA
Could you not have used the grand jury testimony?
And that was the other thing I wanted to clear up. We are entitled to use that testimony, even if the defendant does not testify.
So why then do you say it's a misstep? Wouldn't it have been a reasonable... I mean, look, if I'm the defense attorney, I don't want my client on the stand, right, because he's going to get brutally cross-examined with the grand jury testimony, and I don't want the grand jury testimony in. And what do you know? Neither of those things happened. Is it possible by saying, I'm going to call him, and then having people rest, and then not calling him, I've accomplished that objective?
Well, actually, that was something that we raised in the appellate division and did not raise here. But it's true, there could have been some rolling of the dice gambling on his part where he ended up exactly where he needed to be, which was the very damning grand jury testimony wasn't introduced into evidence. And, I'm sorry.
And don't we need to examine the lawyer to find out if he's a gambler?
Well, it's our position that given the fact that there was only one defense to be had, this court can find that no matter what the 440-10 delivered, that the defendant still had his meaningful right to a fair trial was protected. But...
Can you explain to me why you say the grand jury testimony could have gotten in even if he didn't take the stand?
Because it's an admission by the defendant who is a party opponent.
So why not, then why wouldn't the prosecutor use that?
At the point where this trial was going the way it was, there was no need for it. Had the defense switched and said actually there was a consensual act at 3:30, then the prosecutor would most likely have put that in to show that he was switching horses midstream, to show that this was an 11th hour defense and therefore one that shouldn't be credited.
It's hard to fathom that something that is so devastating the prosecutor's not going to put in, even if they think that's going really well.
That was
if you're correct. I'm going with your argument that the grand jury testimony gets in regardless of whether or not the defendant takes
and I'm
the
very
stand.
confident to stand on my argument.
I'm going with that.
Different prosecutors have different ways of trying cases. This particular prosecutor in this case, in the way it unfolded in front of her, made a decision that she did not need to put the grand jury testimony in. And as it turned out, she was right because she got a conviction. Now, I also want to talk about the fact that there was an acquittal on one of the charges, as if that suggested that the jury didn't actually believe the witness and would have even gone further if defense counsel had chosen a different strategy. One thing about the that particular sex act was, as she testified, she was awake for it and didn't say no because she thought it was her boyfriend. Defense counsel argued on summation she was not physically helpless at that point because she was actually in a position to say no, and mistaken identity is not the same as physical helplessness. So there's actually a legal reason why this jury would have acquitted on one and convicted on the other and still very much credited this particular witness. And in fact, the jury clearly was listening to and crediting defense counsel in this because they considered his arguments very carefully and they acted on them very carefully. Getting back to his overall competence, this attorney, his cross-examination of the victim allowed him to make the arguments on summation that he did. He cross-examined her about her intoxication. He cross-examined her about how her clothes came off in order to show the unlikelihood that that could have happened if she wasn't awake and consenting. He cross-examined her about the positions that she and the defendant must have been in, again, in order to highlight those differences. He called his own witness, the EMT, to come in and say actually the bed was made, which would have contradicted everything that she said. He called a witness to talk about, who took a photograph of the rug outside of the garbage area to show that it had the same colors as the rug inside the hotel room in order to try to dampen the effect of that. He objected to the DNA in a way that previewed this court's decision in John. He also objected to the introduction of the fiber testimony by arguing foundation. This defense attorney was a thoroughly competent defense attorney.
So you mentioned the DNA. Is there anything you want to say about that point?
I think that what we did in below, in terms of what the expert testified to, was enough for this court to draw the inference that we satisfied John. She clearly had gone back to the raw data. And
what was that inference based on? That she said we or?
No, that's part of it. But that's not the inference I'm asking you to draw. There, I think we absolutely, on the combined DNA, we absolutely satisfied John. I mean, she talked about how she reviewed everything and she came to a decision on what numbers should be the alleles. Where there was not as much detail on what she did was the buccal swabs of the defendant and the victim. And our argument there is, my light is on, can I just?
Of course.
It just seems completely inconsistent with the way she behaved, that she would not have gone back and done the same thing with those alleles. And the only reason that testimony didn't come out was, one, it was before John, we didn't know we had to do it. And two, the defense attorney wasn't really questioning those conclusions.
If we disagree with you on that, how can we find it harmless based on all the cross-examination of the victim and all this other testimony that you've just recounted?
Because the defendant, when he is arrested by the police, right at the beginning, says that he had consensual relationship. He said he had a sexual relationship with her and that it was consensual. So the defendant, out of his own mouth, already took identity and identification out of the equation, and that's all the DNA was going to. And that's why the appellate division also found that to be harmless. I see my time is up. I just ask the court to rely for the remainder of my arguments on my brief and to affirm the judgment. Thank you.
Thank you. Counsel?
So I want to begin by just making clear that we've raised an ineffective assistance of counsel claim. We have not raised a denial of counsel claim. We are not obligated to prove a complete absence of advocacy on behalf of Mr. Lopez-Mendoza in order to succeed on our claim of ineffective assistance of counsel. And this is a case that was riddled with reasonable doubt. Even if the grand jury minutes came in, what we know is this was an intoxicated complainant who spent the evening banging on the room next door, declaring that the assailant was in there even after Mr. Lopez-Mendoza was sent off of the floor by the hotel security. We know that this complainant told EMS right after, on the evening of the alleged offense, that the assault occurred right after she was given access to the room. We know that this complainant declared that she testified at trial that she saw the complainant come under the covers of her bed, but EMS, when they went into that room on the night of the alleged assault, said the bedding was not even disturbed. We know that this complainant testified to oral vaginal contact, and there was neither saliva nor DNA found on her. This is a case that was absolutely riddled with reasonable doubt. So This is so a reasonable doubt defense was available to counsel here, an effective counsel who was aware and working and reconciling his defense with what he knew or should have known to be the reality of the videotape in this case, would have considered pursuing a reasonable doubt defense. Again, there are only one of two things happened here. It is, as aptly put, it's either incompetent representation or incompetent investigation. Those are the only two roads here. There is no reasonable, objectively reasonable basis for counsel to pursue a defense that he knew or should have known would be disproven by videotape evidence of all things, of videotape evidence presented by the prosecution. That is ineffective assistance of counsel. And for those reasons, we ask that Your Honors reverse Mr. Lopez-Mendoza's conviction. Thank you.